Dwyer, initiator.
The delegate commander.
Mr. Speaker, colleagues, I come to you today in the name of the Lord regarding the honesty and the integrity of this institution and our oath. I realize that there have been times in the past when I may have offended you or we may have disagreed by what I've said or what I've done. And for that I ask your forgiveness. In 1869, Judge Anson Willis of New York, in his book entitled Our Rulers and Our Rights, wrote the following regarding an oath. An oath is an appeal to God by him who makes it. What he shall say or what he has said shall be the truth. It is the most solemn form under which one can assert or pronounce anything. To utter a falsehood while under oath is perjury, a crime of the darkest hue, one which God himself has declared that he will punish, and one which is made infamous and punishable by fine and imprisonment by the laws of the land. The issue that I hope to bring before you today is an issue that is far greater than you or I. It is an issue that will affect this great institution throughout the remainder of its very existence if the issue is not addressed. Mr. Speaker, today we find out and his opinions above the authority of the state constitution, the Maryland General Assembly, and Maryland's current marriage law. To complicate matters even further, he has gone on to declare himself immune from the process of impeachment in an attempt to obstruct justice and prevent himself from facing the consequences of impeachment charges. The issue before us is not about the AG's opinion itself. It is about a blatant disregard for this institution and those who will follow in our footsteps in years to come. It is about obliteration of the doctrine of separation of powers between the three branches of government, and it is about a violation of an oath of office of Maryland's highest official of law. This body is bound by the Constitution and the rules of the House that we adopt. We as members of this great House are bound by our oath to support the Constitution and the laws of this state. We are not bound to abide by opinions offered by the very constitutional officer who today finds himself facing charges of impeachment. Dear colleagues, I would like to address the authority from which I speak and address you today. In order to do so, I had asked that copies of the Maryland Constitution and the House rules be distributed to your desks. Unfortunately, the Constitution was not permitted to be distributed. The authority for my actions today is as follows. In House Rules on page 69, which the rules are in your desk, regarding the right to petition, the Declaration of Rights under Article 13, regarding the redress of grievance, Article 1, Section 9 of the Maryland Constitution, regarding the requirements of an oath, Article 1, Section 11 of the Maryland Constitution, regarding the violation of an oath of office, Article 3, Section 26 of the Maryland Constitution, regarding impeachment, Article 8 of the Maryland Declaration of Rights, regarding the separation of powers, Article 5, Section 3 of the Maryland Constitution, regarding the Attorney General's authority. On page 71 of the House Rules, referencing Declaration of Rights, Article 13, it states that every man hath the right to petition the legislature for a redress of grievance in a peaceable and orderly manner. I argue that I intend to bring a redress of grievance and that the vehicle for that grievance is a House simple resolution that I'm yet to speak on. Page 23 of the House Rules, under resolutions, provides that a resolution reflecting an independent action by the House, authorized by these rules, or by the Constitution, or under applicable law, shall be introduced as a House simple resolution, as I've done today. Clearly, impeachment is an independent action of this House, authorized by these rules and our state constitution. This is under the authority to impeach, since we are bound by the state constitution and the rules of the House, I would first like to refer to page 80 in the House Rules under impeachment, which clearly states the House of Delegates shall have the sole power of impeachment in all cases. But a majority of the members elected must concur in the impeachment. Let me explain that. That's the point where we cast a vote up on the board whether or not we're going to send the issue to the Senate for a full trial. All impeachments shall be tried by the Senate, and when considered for that purpose, the senators shall be on oath or affirmation to do justice according to the law and evidence. but those persons shall be convicted without the concurrence of 2/3 of all senators elected. You see, the Senate becomes the House where the trial is conducted as in the court of law. Ironically, this is the same language of Article 3, Section 26 of the Maryland State Constitution. Please note that the House rules clearly provide the authority for the House to bring a charge of impeachment. Because I'm going to be ruled out of order before too long. There are no exclusions in the House rules pertaining to the Attorney General. The Office of the Attorney General has written that the Attorney General may not be removed by impeachment by the legislature. Yet on August 23, 1973, at the request of then Governor Marvin Mandel, then Attorney General Francis Birch wrote, "There is considerable authority that all high state officers, i.e. those who have been provided for in the state constitution, or who have been elected to office by the people at large, may be removed by impeachment." Those aren't my words, folks. Those are the words of a previous Attorney General. The following are just some of the cases supporting the Attorney General's finding: Kirby v. Henderson, Ralston v. Blaine, Attorney General v. Tufts. This is consistent with the writing of Mr. Dan Friedman, counsel to the General Assembly, who in his book, The Maryland State Constitution, a Reference Guide, where on page 104 he states, this is his word, "The Attorney General of Maryland, relying on extensive out-of-state authority, has opined that any officer elected by the people at large whose office is created by the state constitution is subject to impeachment under 26. Article 3, Section 26 states that, again, the House of Delegates shall have the sole power of impeachment in all cases, and provides for the charge of impeachment to be brought before this House. Article 5, Section 1 of the state constitution provides for the removal. Understand, impeachment is one action, removal is a secondary action. Removal happens in the Senate, not in this House. But when the Senate is seated for the purpose under oath, Article 5, Section 1 of the state constitution provides for the removal of the Attorney General in the Senate when the Senate seated for that purpose is under oath. It is under the authority of the Senate to be seated for that purpose of a trial that the Senate becomes the court of law only for the purpose of convicting or acquitting the elected official charged by the House. Mr. Friedman, in his March 1st letter to the Speaker, indicates that Article 5, Section 1 of the state constitution prohibits impeachment and requires a court of law to impeach the Attorney General specifically. There is no conflict when you understand that impeachment and removal are two separate actions taken up by the two separate houses. The House impeaches, the Senate removes. The jurisdiction that we're going to hear about, because we're going to hear in a little while that I don't have the jurisdiction, or we don't have the jurisdiction in this House. I want you to follow me closely. Again, Article 3, Section 26. The House of Delegates shall have the sole power of impeachment in all cases. But a majority of the members elected must concur in the impeachment. That is the importance of the vote that I'm going to ask to be put on the board. All impeachment shall be tried by the Senate. And when sitting for that purpose, the senators shall be on oath or affirmation to do justice according to the law and evidence. But no person shall be convicted without the concurrence of 2/3 of all the senators elected. In Attorney General Birch's opinion, he went on to write that obviously impeachment proceedings are judicial. See Yancey v. Commonwealth, Kentucky, 1909. He went on to say they may be likened to the proceedings by indictment in a court of criminal jurisdiction. See State v. Lease, Nebraska, 1893. Now we're going to hear in a little while that we don't have the jurisdictional authority, ladies and gentlemen. And what I've done is I've just laid out for you very clearly that we in fact not only have the jurisdiction, we have the duty and the responsibility to hear the charges and put a vote up on that board. Whether you agree with me or not is irrelevant, but you certainly have the right and the responsibility and the duty to cast a vote on that board when I call for it. Mr. Speaker, it is clear that the Senate, when seated for the purpose of impeachment, in fact, becomes the court of law.